There's another committee meeting that's scheduled for this room at 9:30. So we're going to go ahead and try to get underway so that we don't tie up the room too terribly long. And I know, given the weather, that's why I don't have my coat on, it's soaking wet, but if anyone needs to defrock, feel free. And I know some other members are on their way trying to get here through the weather. So I suspect we'll have people dribbling in. But we thought, after talking with Holly and Ethan and several of the members, the vice chairman, there's been a lot of interest in this Miller case that's you're about to hear more about, and especially for new members, but even for myself and older members that have been here, we've attempted to fix this problem a couple of times over the last term, and it just, for whatever reason, one reason or the other, the two sides of the Capitol hasn't seemed to have been able to get together on it. You guys can have a seat if y'all find a chair down there. I've got some pages here learning today, or there's a heater. You can kind of plop up on the heater too, whatever you feel like doing. So we've got two presenters, one from the governor's office, who's been a former prosecutor himself for several years, in I think California and West Virginia perhaps, Mr. Miller, no relation to the case. And we also have one of our local district attorneys from the Gulf Coast, Mr. Crosby Parker, who is from Harrison and which other counties? Harrison, Hancock, and Son, so large swath of the Mississippi Gulf Coast, who's here. So you guys feel free to decide who wants to go first or who wants to bat second. I am completely open to whichever. Okay. If you could grab one of the microphones, I know it may be a little awkward, but for those people watching online, I think they tell me it's a lot easier for them to hear it if you're speaking into the microphone, perhaps.
Got it.
Introduce yourself, tell us a little bit about yourself, and then dive into the Miller case.
So my name is Nick Miller. I work in the governor's office. I am an advisor focused on crime, public safety, and law enforcement. At the beginning of my career, I was a deputy district attorney for about 8.5 years in Orange County, California. After that, I was an assistant United States attorney in West Virginia, where I prosecuted drug and gun cases. Most of my caseload were large-scale drug traffickers, people moving a lot of weight, primarily of meth, heroin, and fentanyl. That was probably 70% of my caseload. The other 30% were violent felons that were armed with firearms. And so I was with DOJ for about 2 years, and then I joined the governor's office, which is where I am now. We can go to the next slide. So a little bit about some of the cases that I prosecuted federally, and I think it's important because the Miller bill is a great bill for a number of reasons. It allows prosecutors discretion to be able to handle each case on an individual basis. It allows prosecutors to seek life without parole on the worst of the worst offenders, but it also gives prosecutors like Crosby and DAs all over the state the discretion they need in order to treat lower level homicide defendants with a sentence that is more proportionate to their culpability rather than exposing them to a potential life sentence. And I am of the opinion, having been a prosecutor, both state and federal, for a little over 10 years, prosecutorial discretion is critical because we don't ever want to send someone away for a life sentence who doesn't deserve it. And we don't want to be in a position where we can't punish the worst of the worst offenders appropriately when the facts support it. So Vincent Williams was a meth case I prosecuted. He was dealing. They hit his place with a search warrant. They found a little over 2 kilos of meth in his home and a gun. He was prosecuted successfully for distribution of methamphetamine. Bert Tackett was a career offender under the federal guidelines at the time, and that was because he had 2 prior serious drug convictions. So when I prosecuted him, it was his 3rd offense, and he was sentenced to a little bit over 15 years. Sean Price was a guy with a very, very long criminal history. He took the police on a high-speed pursuit. When they finally caught him, they found a distribution quantity of meth in his car. They also found a gun. He pled guilty to possession with intent to distribute methamphetamine and possession of a firearm and furtherance of a drug trafficking crime, and received a little bit over 10 years. Darrell Lowers was what's referred to as an armed career criminal. He had 3 prior violent felony convictions. He was a parolee out of New York, and under federal law, someone who's got 3 prior violent felony convictions, who's caught with a gun or ammunition, is subject to a mandatory minimum of 15 years, which is what Mr. Lowers received. And all of those cases, very, very serious, but all of those cases resolved as the result of a plea agreement. I got a deal that was good for public safety and allowed felons to be punished appropriately, but they also got a deal. And that is critical in our criminal justice system. We need to give prosecutors the ability to make offers that give defendants a benefit, but also give them the ability to do what is their most important priority, which of course is protecting the public. Now, the last case on there is one that I wanted to mention, Austin Miller. Why is this case important? Austin Miller was in his early 20s. He was stopped by the police with about a quarter of a kilo of methamphetamine, as well as a gun. He had no prior felony convictions, and but for the fact he had a gun, he would have been safety valve eligible, which would have gotten him around the mandatory minimum. With the charges, possession with intent based on the weight and possession of a firearm in furtherance, I could have hit Austin Miller with a mandatory minimum of 15 years in federal prison. I didn't do that because he was 24 years old. He had no felony convictions on his record, and hitting him with 15 years would not have been in the interest of justice. And I didn't think that was appropriate. So what did I do? I charged him with just the drug offense, a mandatory minimum of 5 years. And at sentencing, I asked for the minimum. I asked for 5 years, even though his potential exposure was far greater, because Austin Miller's criminal history and his conduct warranted a sentence far less than the 15 years I could have obtained. And that really is emblematic of the importance of prosecutorial discretion. Thankfully, I, as an AUSA, was not mandated to seek 15 years against this individual for someone who didn't deserve it. And that is something that's so important about the Miller fix. Next slide, please. Okay, Miller v. Alabama. I know that I'm sure everyone on the committee is pretty familiar with this. Basically, long and the short of it, mandatory life without parole for juveniles convicted of homicide is prohibited. It cannot be mandatory. Now, the consequences, and Crosby, as a lawyer in the state of Mississippi, and again, I am not, I am an active member of the California and DC bars, but I'm not a lawyer in the state. Crosby is going to be able to get into the details as to the consequences of this decision that he is seeing in court and what his prosecutors are having to confront. But just from a brief overview, we currently have no uniform standard in the state. My understanding, based on my conversations with Crosby, is that the judges basically are trying to fashion their own way of dealing with these kind of cases because there is no legislative fix. Now, what does that present? If you've got different judges, maybe even in the same county, doing it differently, let alone judges all across the state perhaps doing it differently, we potentially could run into an equal protection issue. We could potentially end up with a situation where perhaps the jury instructions in one county are more favorable to a defendant, or they may be less favorable, and we can't and we don't want defendants being treated differently based on where they committed the crime. We want them to be treated the same no matter what courtroom they're in. Another big issue with Miller is right now, juries are forced to grapple with aggravating and mitigating facts. That is something that is so pivotal about this fix. It allows judges, and it puts the decision as to the aggravating and mitigating factors in the hands of judges. Now, why is this important? It's important because, as we all know, judges are the individuals who are tasked with deciding issues of law. We entrust juries to decide issues of fact. Judges decide issues of law. And as Crosby's going to get into in more detail, these are really complex legal issues as to whether or not someone is deserving of LWOP versus life without parole. And we want these decisions to be made just like we entrust judges to make decisions regarding relevance or deciding whether evidence is more probative than prejudicial. These are decisions that we entrust to judges because they are in a much better position to be able to delve through these really complicated legal issues in order to fashion a sentence that is appropriate. The other issue, early parole endangers the public. So I met with Senator Simmons yesterday, and Senator Simmons, when you and I discussed it, it was my understanding that they became eligible for parole in only 10 years. Crosby's office has done some research. The parole rules have changed. So now they become eligible for parole in 20 years. Let me tell you all what that means. Right now, the options, if someone is charged with capital murder, they can go for life without parole, but it has to be unanimous in the jury. If the jury does not find unanimously that LWOP is appropriate, then what someone is subjected to is a sentence where they're eligible for parole in 20 years. Now, what's the problem with this? The problem is twofold. It's one, perhaps a person is not deserving of 20 years. Well, murder 2 in this statute has a determinate sentence of 15 to 30. So it allows Crosby and his prosecutors to give lower level defendants who perhaps shouldn't be getting 20 years. It allows them to offer a 15-year sentence on a murder 2 charge and thereby give a benefit to someone who is deserving of one. But it also allows him to say, you know what, 20 years is not appropriate. It's too light. So maybe instead of exposing that defendant to life without parole, Crosby or one of his prosecutors says, we'll offer you 25 years or perhaps 30 years. And that way they have a chance of getting out in the future. They have an ability to avoid a life sentence, and we're vesting the discretion for offers in prosecutors, which again is so critical to public safety. Next slide. So what the bill does, I am a firm believer in the idea that most cases should be able to resolve. There are a small percentage of cases that have to go to trial. But what Senate Bill 2022 does is it allows prosecutors the discretion to punish the most violent offenders, give a break to those who deserve it. And what is the benefit of being able to reach a deal where there's so many? One, finality for victims. Victims don't have to worry about whether or not a conviction is going to be overturned on appeal. They don't have to worry about whether or not they're going to have to testify in a retrial if for whatever reason the conviction is overturned. Appeal waivers. That was critical for me as an AUSA because when I would get a plea deal on a defendant, it contained an appeal waiver. Now, this is a tremendous benefit to taxpayers because they're not having to pay for appellate litigation. It's a tremendous benefit also for prosecutors because when I had a defendant who had pled to one of my offers file an appeal in the Fourth Circuit Court of Appeal, I didn't have to draft or file a brief. All I had to do was draft and file a motion to dismiss, which was subsequently dismissed by the appeal was subsequently dismissed by the Fourth Circuit, which obviously saves lawyer time, court time, taxpayer money. It's good for everybody. And I want to come back briefly to a very important factor in this, which is that it provides judges with the ability to make decisions regarding mitigating and aggravating factors, because it is so critical that juries not be forced to deal with really complex, convoluted legal instructions, legal issues, whereas judges are in a much better position to be able to make a decision as to what mitigators are present, what aggravators are present, and then be able to fashion an appropriate sentence. Next slide. And again, going back to the issue of making a deal, discretion is important because what we want here, we want prosecutors to be able to look at each defendant, each case individually. The facts are different, the record is different. Mitigating factors, perhaps mental health, perhaps abuse during childhood. We want prosecutors like Crosby to be able to consider all of these factors and then to be able to fashion an offer that is good for public safety and also gives the defendants a benefit, so perhaps they won't be having to face a potential life without parole sentence. So discretion is something that's good for everyone, defendants, the public, and prosecutors. Next slide. It's important, I think, that we focus on the fact that the bill is not political. It allows the worst offenders to be punished, but it also allows mercy and compassion for those defendants for whom a life sentence is not appropriate. And because it provides prosecutors the ability to perhaps offer a lower sentence, it incentivizes defendants to be able to accept an offer to avoid having to go to trial and potentially facing a life without parole sentence. Next slide. And I had mentioned to the chairman yesterday via text, I think this bill is critically important. It is a major priority for the Prosecutors Association. It's good for all of your constituents. It makes our streets safer. It allows juvenile murder suspects to be treated individually and appropriately. It allows us to keep our communities safe. And I very much hope that I can win all of your support on what I believe is a critically important bill. And I so appreciate the chairman taking the lead on introducing it. Crosby?
Thank you, Chairman. As stated, Crosby Parker, DA for Harrison, Hancock, and Stone County. I think we can all admit that juvenile violence is going up. We're seeing it more on the coast. We're seeing more felonies. We're seeing more murders. Since 2012, when that Miller bill came out, our statutory guidance on how to prosecute and sentence these cases has not been in compliance with the U.S. Supreme Court. So after the Miller bill, or after the Miller case came out, all the juveniles that were sentenced to life sentences for murder or capital murder had to be sent back for resentencing. When they came back, the judge had two choices. That's it. Life without parole or life notwithstanding the parole statute. The fact that we have to say notwithstanding a statute tells you that something's wrong and it has to be fixed. Now, one of the individuals, and I think y'all remember last year in May, James Williams, he was a capital murder conviction twice over, got parole at 17 years. 27 members of the House wrote a letter to the parole board showing outrage on how did this happen? And the family was outraged. This fixes that. And it fixes it because, as Nick said, it doesn't just give us the opportunity to still go for a life sentence in the most serious cases, but it also gives a lot of other options to take into consideration what to do with a juvenile. I'll give you a quick example of cases that we see on the coast on a pretty regular basis. I've got a 17-year-old and two 15-year-olds that go to commit a robbery. In that robbery, the 17-year-old kills somebody. That's our felony murder statute. That's capital murder. But those three defendants don't deserve the same punishment. There needs to be discretion on behalf of the prosecutors on how to handle those cases. Otherwise, we don't get resolutions. And if we don't get resolutions and they all go to trial and there's only one or two options, well, we're going to go for the option that is certain, which means we don't put it in the hands of the parole board because our victim's family want to know how long will someone go away for, because that's a finality that's needed. Every time they have to come back to a parole hearing, all you're doing is opening up those wounds. And we get those phone calls. This gives options. And the concern is, okay, well, you just want to convict a juvenile and put them away for life. That's not what this is at all. If you read it, it gives different options and it puts it in the judge's hands. I want discretion from a prosecutor to be able to resolve the case. Defense counsels want options. They need to be able to go to their clients and say, these are our options. I just had a case this week, a 16-year-old and an 18-year-old, both charged with murder. The only way we could resolve it is to make this Frankensteinian, we'll plead this one to second degree so that we have discretion. Well, there are some cases that you can't do that. There are some cases where the defendant wants to go to trial and they should have a right to go to trial, but they won't risk it if they could get a life sentence versus 20 to 40 for a first-degree murder. And I know I'm talking with some specifics of something that I deal with every single day, but I want you to know that when you read this, it gives options. It's in compliance with the U.S. Supreme Court. It's in compliance with the Mississippi Supreme Court, and it gives options to both defense counsel and to prosecutors, and then gives judges discretion. Because when you're dealing with these juvenile cases, there are no cases more difficult when you're trying to fashion what's right for a 15 or 16-year-old that has taken another life. That is very difficult. This allows us to resolve those cases, and it allows every party to have some finality. I could go on, but I'm happy to answer any questions that the committee may have.
Thank you both for being here. I have just one question to begin with. So for those of us who don't practice criminal law on a daily basis, what is defined as a juvenile for these purposes of committing murders, in other words?
They have not reached 18. So
17 years and under.
17 and below.
And that's the only segment of the population that this bill would seek to address is 17-year-olds or under who commit murder. Or
Yes,
commit
Chairman.
life, in other words.
So the Supreme Court said when dealing with minors, 17 and below, you cannot have a mandatory life sentence. So they specifically said our sentencing procedures are not in compliance, and so they changed that. So this only deals with minors, which is 17 and below.
So I think Senator Barnett had a question to begin with. You can direct it to whichever of the presenters or both of them, Senator Barnett.
Thank you, Mr. Chairman. My question is, when we talk about the sentencing on the juveniles, are we taking in consideration for those individuals that commits a murder at a school? Because we've seen that on the rise where you have school murders. And so I don't want the parents to think that if there's an individual that comes in and does a school shooting at 15 or 16 years old, then they fall under this model, because I think we need to be careful when we talk about that. I think there needs to be some assurances that if it's a single murder, I can understand that. But if someone walks into a school with a loaded weapon, a loaded gun, and there's several children that's killed, then I think that we need to go back to the life without. Do what now?
No, that is a great question, because what this leaves in place is the option to still do life without parole. So I could give you examples just like that are so heinous that the district attorney's office will go with life without parole. This leaves that in place, which is what I like, is it leaves that in place and then gives discretion on other type of murders involving juveniles.
And my other question is, I know there's been some cases where an individual committed a crime at 17 years old, didn't go to court until maybe they was 18 or 19. On the day that they went to court and had to go to trial, now they tried as an adult. So does this protect those people to make sure that they will be tried in court at the time of age that the crime was committed, or do they be, am I making sense?
Yes, absolutely. So whatever age the defendant was at the time that they committed the crime is what is going to be looked at. The only time circuit courts, DA offices prosecute minors is if they commit a crime with a deadly weapon or they commit a crime that carries life. Otherwise, it's going to be handled by the youth court. So this statute deals with minors, and it deals with second-degree murder, first-degree murder, and capital murder. So it doesn't deal with somebody who was 17 and commits a larceny of a car and then turns 18. This only deals with the serious violent crimes in which life is taken.
Got one more question, y'all, then I promise I'll be. But I know there's a law on the book that said if you're an adult and there is you have a vehicle accident and you drank a little bit, but you were not over the limit, then you're not really charged with, you're not charged with a DUI because you're under the limit, even though it resulted in someone else being killed. There is a juvenile section that says if you were 17 and you're still not at the legal amount, but you can still be charged differently than if you was an adult with the same amount of alcohol, which is a greater sentence than if you were an adult.
And that's something I can look into. I'm not quite familiar with that right now. This statute just deals with second degree, first degree, and capital murder.
This is a first degree and second degree murder that I'm talking about. If the accident results in the death, even though you are a juvenile, then the alcohol content would be less than it was if I was an adult and committed the same offense.
I'd have to look at that.
Senator, I was just going to follow up on a question. I think something that's so, one of the many things that's so good about this statute is that for your example of a school shooting, a mass shooter, it allows Crosby and prosecutors all over the state to seek life without parole on those most heinous cases. So it allows both ends of the spectrum. It allows them to seek LWOP on the most heinous cases, but it also allows him as prosecutors to show mercy when it's warranted. And Crosby, one of the things I was going to ask if you could address to the group is the problems right now that juries are having to confront in dealing with these issues because they're the ones that are having to make these decisions.
So whenever Miller v. Alabama came out, they gave out numerous factors of why a mandatory life sentence is prohibited. And they said, these are the things that need to be considered. And they just threw it out there, right? One of the terms that's used all the time is incorrigible. What does incorrigible even mean? And so this is case law that was made by judges that is coming down that now we just have to give to jurors. And jurors have so many questions because these things are not defined. They're not defined. And one of the things that we've had, and when they came back for resentencing, judges made these decisions. But now, the way it is, all future cases, juries will have to make the decision on whether to do life without parole or life with parole. And when you go with those factors, you got judges doing different things, and the definitionals have not been provided to anybody. And I'll tell you, that is a huge problem, a huge problem.
One of the most important aspects of the bill is allowing judges to make decisions really hard.
All right, Senator Wiggins, or Chairman Wiggins, I apologize. I don't mean any disrespect. Almost all of you guys are chairmen and ladies, so I say senator, I mean chairman and senator.
Thank you, Mr. Chairman.
Yeah.
And Senator. And Mr. Chairman, if you may allow me, and for the benefit of our young students and all, my questions, I'm going to start off with kind of taking us some basics of criminal procedure and law. So so what you were saying, plea bargains drive the criminal system. Am I accurate in saying that?
Absolutely.
Okay.
Absolutely.
So our system, we cannot try every single case that comes before prosecutors. Am I correct in saying that?
For example, we have 4 courtrooms running every week, and in every courtroom, there are over 40 cases in there. At most, we can try 4 cases a week. So there is no way the system can run without plea bargaining and pleas.
So, and in fact, the ethics laws encourage plea bargaining in criminal cases.
Yes, sir.
So when the media and other people start railing about plea bargains, they're actually wrong because the law requires us to look at that to drive the system.
Oh, absolutely.
Okay.
100%, Mr. Chairman, and I would just refer back to the case of Austin Miller. Got 5 years making a plea bargain.
And then the trials that you do have, in essence, and so a plea bargain generally is you're offering less time than if you go to trial and get convicted and are sentenced on that.
Without a doubt.
Okay, because that's the incentive to plea.
That's right.
So if the penalty, I'm just making up numbers, but if the penalty is 40 years and the plea offer is 20, then they have an incentive. But if the maximum is 40 and they go to trial and they're going to get 40 and they get a plea offer of 39, well, there's no incentive because they might as well go to trial and get one juror to say they're not guilty and they go free.
Absolutely.
Okay. So then there is, I think what gets confusing is the Miller case is only applying to murder cases, correct? So it doesn't apply to DUI, it doesn't apply to grand larceny, it doesn't apply to any of that. Am I correct?
You are correct.
And what the Supreme Court said was that mandatory life without parole. Mandatory is unconstitutional under the US Constitution. Is that right?
Yes.
Okay, so it's the mandatory part of it that is the problem, which is what our statutes had. Am I correct?
Yes.
Then in the penalties for murder actually differ depending on the type of murder it is. You had capital murder, which is death. You had life without parole, but then you also have life. Okay, I think that confuses people. What is, under the law, how is life defined?
Life is to 65 for first degree murders. And then you're eligible for parole at that age.
So you actually, and this has been this way for decades, if not forever, that if you're convicted of what I call simple murder, you actually are eligible for parole, and it's been that way for a long time.
Yes.
And what that means is that if you're a 20-year-old and you are at 65, you actually have to serve 45 years before you're eligible for parole.
Yes.
If you're 60 years old, let me back up because it gets a little, but if you're 50 years old and you're convicted of murder, you actually have to serve 15 before you're eligible for parole.
Yes.
Okay, so thank you for the basics. So then on this, so because of the Miller case, what the judges, it's about looking at those juveniles and deciding, is life without parole appropriate under the facts of the case, or is it not appropriate? Is that right?
Yes.
Okay. And so what this is doing is allowing y'all, and I say prosecutors, to be able to do the same, come back on these cases and either make plea recommendations and make a sentencing recommendation. Because actually, correct me if I'm wrong, but on these juveniles, if you go and say, look, because of the facts of the case, I'm going to recommend 20 years and not life without parole, they'll take 20 years and it's done and over with, and you don't have to bring the victims into the court and go through this all again. Is that right?
Absolutely.
Okay. So this is giving, I guess, the parameters for y'all and for the judges, and really making it easy on the juries.
Absolutely. And everybody, the families, when we meet with them, as you know, when you meet with families of victims, you're trying to explain to them what the process is and what are the different options. This gives them a lot of things that they have an opportunity to weigh in on.
Now, it is known that this bill, or a version of it, has tried to get passed in this legislature for 5 to 6 to 7 years.
Yes,
And
sir.
what happens is people come out of the woodwork and say that you're letting people out of prison and that you're going to do, is that in fact what we're doing?
Absolutely not.
And because, first of all, what we have right now is unconstitutional under the US Constitution
Yes, held by the Supreme Court.
by the Supreme Court. So we're actually treating people, let's just say, badly.
We're not in compliance.
Okay. And then my last question will be this, because I think it's illustrative of what y'all are talking about, and I think Crosby, you understand. About 10 years ago, the legislature passed the second-degree murder statute, which, from what I've heard, has been a really good thing, because up to that point, you had manslaughter at 20, or you had the death penalty. Can you explain how that's worked and how that's happened?
Absolutely. So before the legislature gave second degree and somebody was charged with murder, they would either be convicted of murder, which carried life, simple life, or manslaughter, which was a maximum of 20 years, eligible for parole at 10.
But let me interrupt you there. But actually, if the facts, what would happen is the grand juries, and let's just say prosecutors would do what we call overcharge, because for a capital case that probably didn't lend itself to that because manslaughter was too less of a crime, let's just say.
We would want to give the jury options. But there was such a huge gap that when second degree came out, and I can tell you, second degree has resolved a lot of cases and done justice for the victims of the family, as well as giving finality without appeals to a lot of cases. And I'm telling that's what this does, is it gives that gap where prosecutors don't just have to go for life, except in the cases that warrant it. Look, if the case warrants it, we're all about putting that in front of a judge and putting forth those factors. Yes, sir. I'm sorry, Mr. Chairman. I know.
Thank you, Mr. Chairman. The decision to indict and what to seek, obviously, the grand jury is going to make that determination. But I'm a little confused. If it's a minor and it's a non-capital offense, you can certify them and they come up to circuit court to be prosecuted as a felon, correct?
Yes, the youth court would have them certified and then it'd be sent up to the DA.
That's separate and apart from this issue.
Yes, sir.
Then in this particular case, you're talking about a murder. Are you saying you don't have to certify, or you have original jurisdiction at the circuit level?
We would have original jurisdiction in cases where a minor commits a crime with a deadly weapon or the crime carries life. So in this case, if they take a life and it's second degree murder, first degree murder, capital murder, we have original jurisdiction.
You don't have it over manslaughter or some lesser.
Unless it's committed with a deadly weapon, which most likely in all manslaughter cases, we would have it.
So at that point, and I just want to make sure I'm understanding this, because a lot of times we get into the legalese and then it goes off the rails. Someone commits a taking of a life that's criminal, that's under the age of 18, and you have jurisdiction. Your issue is with the life sentence. Miller's issue is with a mandatory life sentence. But am I not understanding y'all to say murder 2 is in your tool belt to offer them already?
Murder 2, it all depends. So when they've been charged with capital murder, felony murder, murder 2 would not fit. Murder 2 is the taking of a life with a reckless indifference, where capital murder is if it's committed in a robbery. And so when it goes to capital murder, our only options are the life without parole or the life notwithstanding the provision of the parole statute.
Well, respectfully, I've pled to things that almost made me worry when my client stood up there that they were violating their oath when they told the judge, I'm guilty of that.
And that's the thing, when you have to do a Frankensteinian plea where you're trying to do a square peg round hole to plea it to something less because you don't have the options, are we really been intellectually honest with that plea?
Well, with a murder 2, and I'm not saying we don't need to try to conform Miller, but I don't want to leave the impression that we don't have the tool already to take a second degree plea, which is day for day.
Right.
So, I mean, that we know what that sentence is going to be. And I believe you stated it had 15 to 30 was your option or your range within murder 2.
Right.
All right. So we're dealing with a 17-year-old who takes a murder 2 plea and they're out at 47 at the max.
Right.
All right. So I guess I'm a little lost in, if you proceed to trial, you are creating the Miller problem as the prosecutor. If you believe that's a case that needs to go to trial and it's a life sentence is your only option, you're saying that's the gap we're trying to fix.
Right. So by saying that we're creating, so if the grand jury indicts a minor for capital murder, right? And the minor wants to go to trial on that capital murder.
Issue there. If the defendant's demanding to go to trial, that's their choice. Now you're saying you're handcuffed.
Right.
All right. Did the Jones case not relieve Mississippi of that? Did they not go through this exact scenario that when they were sentenced, that the Miller factors were enumerated and they reappealed their sentence because they said, well, you didn't make a finding of incorrigibility. And the United States Supreme Court said, no, they upheld that sentence because the judge had gone through the Miller factors in that particular case, living with his grandparents, mental health issues,
Right.
abuse, and all that. So I just want to make sure, are we, I don't want to stand up here and say we're out of compliance with Miller if Jones says that we are doing it correctly.
No, well, what in the Jones, and I don't know that one specifically, but what happened is all of those cases came back for resentencing. So they came back for resentencing. The judge had a Miller hearing is what we call it. Those factors were considered, and I guess in that case, he was given life without parole, which he then appealed. And then on appeal, they said you didn't have a specific finding of incorrigible. And what the law says is you're to consider all these factors. It doesn't say you have to find any specific one, you just have to find them. And they said the judge did that. So the judge's rulings were all in compliance, but our statute still has it to where you either have life without parole or life notwithstanding our parole statute. And this fixes that statute problem.
I think what this bill does in terms of time, the fact that it gives options, totally legit, but have to have client. And finally, indictment, probably wrap that with the package, probably decide what.
And he could have taken that same plea under murder too.
Absolutely. But as you know, just this past week, the defendant was faced with, I'm either going to go to trial on a capital murder or I can plead a second degree. If I go to capital murder, I'm going to get life without.
That's right.
And so it was really at the request of the defendant to get the second degree. It wasn't at the request of the prosecutor. They brought that to us and we evaluated.
And then the last thing, I understand that it's kind of bifurcated. You have a finding of guilt, and then you do the sentencing phase, which is in the hands of the jury, which I can see is the biggest issue because they only have two options, is life without or life. Okay. And in this case, you're going to let the judge sentence if we follow what's recommended here, even if someone receives a capital murder plea, the judge is going to affix the sentence. Is that correct?
Yeah.
So we would take away the sentencing from the jury, where now they only have life without or life, then we would just turn sentencing over to the judge.
Thank you, Mr. Chairman. I have a few follow-up questions from, the questions that were raised by Senator Sparks and the answers that you all gave. As it relates to the tools, currently under Mississippi law, if a person commits capital murder and at the time of the offense, he or she was a juvenile, what's the penalty under the current law? Capital murder.
Capital murder, so somebody commits a capital murder today who's 17 years of age, and we take them to trial on a capital murder, they're convicted. It's gonna be, at the sentence, at the Miller hearing, it's gonna be life without parole, or it'll be life notwithstanding the provisions of the parole statute.
If a juvenile commits first-degree murder under our current law, what's the penalty now?
So simple murder is life, eligible at 65. The Supreme Court in Parker v. State held that that was the equivalent of a life sentence. So it's going to be life, or once again, life notwithstanding the parole statute. So once again, it's either life or life notwithstanding the parole statute.
Under our current law, what is the range? What's the minimum and the maximum for second-degree murder in Mississippi? As a prosecutor, if a person who is a juvenile at the time he or she commits murder and is charged by a grand jury, a case that's presented by the district attorney's office, correct, to a grand jury, and the grand jury comes back with, say, capital murder or first-degree murder, considering the age of the juvenile and the mitigation packet that may be presented by the defense attorney, wouldn't you, as a prosecutor or any prosecutor in the state of Mississippi, have the right to consider whatever factors and make a determination at plea bargaining, like Chairman Wiggins was talking about, to give a juvenile a 40-year sentence on a second-degree murder? Could you do that today?
That circumstance, yes. Can I give the flip side of that, though?
I guess what I'm just trying to make sure is clear. Under our current law, there are juveniles right now in the state of Mississippi who could be sentenced to second-degree murder and serve 40 years in the Mississippi Department of Correction day for day. Is that true? Okay.
Second-degree murder, very specific, where capital murder is our felony murder statute.
Understand.
So there are a lot of cases where capital murder is the correct charge because of the person's role in it. So if a defendant is charged with second-degree murder and they didn't pull the trigger, instead of they were helping an accomplice of a capital murder, you're not going to be able to prove that case in front of a jury. So you have to have that capital murder statute or indictment if you're going to go to trial. Does that make sense?
Under the bill before us, are we reducing that from 15 to 30 years?
On the second degree,
Yes.
the second degree is from 15 to 30.
And why are we reducing it?
Give the option to actually give the judge the option.
and we're reducing the minimum from 20 years to 15, and we're reducing the max from 40 to 30.
Still the option, you can still go with life without parole.
Huh.
You can still put that in front of the judge if the facts and circumstances warrant
And-
it.
And my, and my last question is, why will we take what should be, or what has been determined by the U.S. Supreme Court that should be handled by juries? Why will we take that away from juries, regular day Mississippians, and put it in the hands of just one person? That's the real question.
But the Supreme Court didn't say for jury, they said for sentence, right? They didn't say for jury. And what they really did is they left it to the legislature. That's, the case law comes out, and then they're expecting the legislature to come in and fix their statutes to codify it so that we know how to use it. Because right now, the Supreme Court in Miller versus Alabama just threw it out there. And now everybody's had to struggle with how does this really work on the ground level in each of the prosecutors.
Senator England, we've only got like 5 minutes, so we'll try to get you and Senator Gill both in if possible.
Okay, yes, and I'll be very quick, I hope. First of all, thank you all for coming and talking with us. It's been very informative. I don't practice criminal law. As you can tell, a lot of the lawyers in this room do, and I think this is a very smart committee for that reason. You get good discussions in here, and I've enjoyed the back and forth. But one thing I want to make sure of, Crosby, that you mentioned earlier, and before I say this, I'll say that I believe that a version of this bill, I've only been here since 2020. Senator Wiggins says we've probably been dealing with this issue for 6 or 7 years now. A version of this bill passed the Senate in 2022, and then it failed in the House, didn't come out of committee, if I remember correctly. And Crosby, you mentioned the case that got a lot of attention recently, where a double capital murder convict was released on parole. And there were 26, I believe you said, House members, 27 House members that signed a letter in outrage that had happened. And I just want to go back to point out that I think you said this would have fixed that issue. Is that correct?
Absolutely, absolutely, because what happened in that one is when they came back for resentencing, between the two options, that judge gave life with, notwithstanding the parole statute. So when that individual, I think it was 17, 18 years, was given parole. And then that's when the family was outraged. That's when the 27 members of the House Representative wrote that letter. They said, how did this happen? And it happened because it was a change in the law. It came back and it took it out of the court's hands, put it in the parole board's hands, which I'm not going to talk about any other organization, but parole boards change, right? The individuals on it. What this does is it gives us an opportunity to have some finality for the families so that they know exactly what to expect.
That's right. And that's one thing I'm glad you mentioned that, because you guys are, and I think Senator Sparks mentioned this when we had a a highway patrolman retiring recently, and I thought it was a very good comment. You know, we sit here in this building, we pass laws that then get passed on to you guys to actually enforce and put into play. So you guys are on the front lines of what we pass. And we have to remember that you guys aren't just dealing with, you know, you might have a juvenile that's done something and you want to show compassion when you can, but you also have victims and the families of victims that you're also dealing with. And it seems to me that if we pass this, based on what you said in that one particular case, we're kind of closing a loophole here to where you are able to tell a family and the victims of a family that, you know, this is what's going to happen. And you can also tell the defense attorney when you're in plea bargaining, like, look, this is what's going to happen. So we're really closing a loophole here that I think needs to be, I think it needs to be done, and I hope we can get it. Is that correct? Is that what we're doing?
Absolutely. Absolutely. Thank you.
Yeah, thank you all for being here. I appreciate it.
Capital murder, there's levels. Capital murder, 25 to 50. First degree murder, 20 to 40. Second degree murder, 15 to 30.
Well, from what I see across the state of Mississippi with so many repeat offenders, I think it all depends on the judge and the prosecutor. So I can't say that we're going to fix every problem with this, but we may need to do something.
But this is for juveniles only. Again, we're only.
Right. And I think the problem is mainly juvenile offenders is a lot of what we hear nowadays.
Well, Mr. Miller and Mr. Crosby, I appreciate you. And Mr. Parker is speaking not only on behalf of himself, but I believe you're the chairman of the District Attorneys or Prosecutors Association for this year?
Yes, sir. President of the Mississippi Prosecutors Association. I can tell you this is our #1 legislative.
Great. So these are great questions, great answers. If anybody wants to hang around afterwards and talk to these two gentlemen, I'm sure they'd be more than happy to do that. But with that, we'll do a motion to rise and report. Rise and report. Thank you.